97 separate claims, 0 survived. That is the number that should stop you before anything else in this story, because it tells you something a simple headline never quite manages to convey. This was not a narrow loss, not a case where a handful of allegations held up while others quietly fell apart along the way.
A good day for them, a good day for journalism, a great day for press freedom, and a very bad day for ginger, whining, treacherous little weasel. More on that in a moment.
Harry brought 97 separate claims against the publishers of the Daily Mail and the Mail on Sunday, built across an 11-week trial that stretched over 45 actual court days of testimony, cross-examination, and legal argument. And the judge dismissed every single one of them. Not most, not the majority, all of them without exception. Harry reportedly arrived in Britain for this particular week with 2 entirely separate speeches already prepared in advance, one written specifically for a win and one written specifically for a loss.
But we can all sit here and laugh and poke at him and say, you have turned yourself, mate, into a humiliation. Because the High Court judgment found that Harry gave limited evidence on the issues at the heart of the case and strayed beyond factual evidence while in the witness box. In other words, he lied.
He was actually at a public Invictus event taking place at Chatham House at the exact moment the verdict came through, surrounded by veterans and with cameras actively rolling throughout, when someone quietly stepped over to him and delivered the news of the verdict in person. He never once got to use the version of the speech he had genuinely hoped and prepared to use. Let's start with the specific detail that actually decided this case in practice, because I think it genuinely deserves considerably more attention than the headline number alone tends to receive in most coverage of this story. Under oath, in front of the full court, Harry testified that his inner circle was tightly guarded. No close friendships with journalists whatsoever. No one positioned in a way that would allow them to leak private information about him. My social circles were not leaky, he told the court directly. I want to make that absolutely clear. That specific claim was the foundation the entire 97 claim case rested on, because if his circle genuinely was as leak-proof as he described under oath, the only remaining explanation for how private stories consistently reached newspapers over the years was unlawful information gathering, phone hacking, private investigators operating outside the law, exactly the conduct he was accusing the Mail of throughout the trial.
Isn't just a defeat of a civil case. This is Harry being exposed as not telling the truth under oath in the King's Court. This is serious stuff.
Then the Mail's legal team produced a set of years-old Facebook messages between Harry and Charlotte Griffiths, the Mail on Sunday's royal writer, and the tone of those messages did significant damage to the picture Harry had just painted under oath. The messages were casual, familiar, unmistakably friendly in exactly the way a close acquaintance's messages would be. "Hi, it's H," one read, followed by, in case she was confused by the photo. Griffiths replied, "Hello, Mr. Mischief." The exchange continued back and forth on a first-name basis across multiple messages, and at one point specifically referenced missing their movie snuggles together, a phrase that instantly became one of the single most quoted and most widely circulated lines to come out of the entire 11-week trial, repeated across nearly every outlet covering the case.
My view, and I've said this to you a lot before, is I just think if I'm King Charles, enough of this bullshit. Just strip them of the titles, Meghan and Harry, let them do their thing, stop the drama, the circus that applies to them everywhere they go, and just keep them away from us.
According to arguments presented in court, Griffiths had kept these messages private for more than a decade before they surfaced during the proceedings, introduced specifically after her credibility had been challenged. That is precisely the kind of contradiction that carries genuine and lasting weight inside any courtroom setting, regardless of how relatively minor it might initially appear to be when viewed on its own, outside the specific context of a sworn legal proceeding. A witness who states under oath in front of a judge that no relationships of this kind existed at all, and is then confronted with direct documentary evidence proving that at least one clearly did, invites much closer scrutiny of everything else contained in their testimony. Not because the messages themselves were scandalous, but because the contradiction itself becomes the story.
I mean, Meghan is a source of evil. I've said it many years ago, and it didn't make me popular with some people, but she's bad.
Reports coming out from inside the courtroom itself describe the presiding judge intervening more than once during the testimony specifically to redirect Harry back toward answering the actual questions being asked of him rather than expanding into broader statements, and separately describe exchanges between Harry and the Mail's legal team that grew noticeably more adversarial and more tense as the testimony continued across multiple days.
I never witnessed anything in terms of what we were accused of doing. And the accusations were despicable. So I feel emotional. I feel vindicated, Piers, is how I feel.
Well, you've been completely vindicated, as has the Mail, completely.
Stay with me, because the human cost sitting inside this case deserves real attention before we get to the reactions. Royal journalist Katie Nicholl, who has covered this family on Fleet Street for roughly 20 years at this point, across multiple reigns and multiple generations of royal coverage, had 17 of her own individual articles examined in detail during these proceedings. Her sources and her specific reporting methods were challenged directly in open court, in front of lawyers and a judge, at the exact same time she was recovering from major cancer surgery. At one point, she said she could barely manage a flight of stairs and still had to dig through old notebooks to defend reporting she had completed years earlier. Sit with that specific combination of circumstances for a second, because I think it deserves real acknowledgement, recovering physically from major surgery, and simultaneously having your entire professional credibility built up over 2 decades of work, publicly tested and challenged in a courtroom, all happening at exactly the same time in her life.
Not a good day for Prince Harry, not a good week for Prince Harry, and I just have no more sympathy for this man. All he does is whine and complain and expect everything.
When the ruling finally came down, the judge did not simply dismiss the claims connected to her specific reporting and move on. He went considerably further, describing her explicitly as a credible and impressive witness, and formally accepted her evidence as honest and reliable. For any working journalist, a finding of that kind delivered directly by a judge on the record in a major case carries enormous professional weight that extends well beyond this single trial. Speaking publicly afterward, visibly emotional as she spoke, Nicholl reflected honestly on what 20 full years working in journalism had actually and genuinely involved. Not the glamour that outsiders sometimes imagine, but the far less glamorous reality of knocking on doors repeatedly, building genuine trust slowly and patiently over time, and earning reliable sources through years of consistent, unglamorous, relationship-based work. She described one particular source in specific detail, a woman in her 70s who had been genuinely close to the late Queen during her lifetime, and who eventually agreed to speak with Nicholl only after years of relationship building, because Nicholl had earned that trust gradually through old-fashioned, patient, relationship-based reporting rather than through anything even remotely resembling unlawful methods. "I did journalism the hard way," she said. "I never witnessed anything in terms of what we were accused of doing." If this breakdown is giving you the specific details that got genuinely buried underneath the simple headline version of this story that most outlets ran with, the like button helps this channel keep doing exactly this kind of deeper analysis going forward. Hit it and stay with me, because there is also a genuine and important side of this case that actually worked in Harry's favor, and I think basic fairness requires naming it properly before we move on.
It's estimated the case could cost as much as $60 million once legal fees and trial expenses are fully calculated. Under UK rules, Harry could also be ordered to pay a significant portion of the Associated Newspapers' costs, potentially adding millions more. I would argue 50 million more plus 60. It could be 100 million.
Not everything that came out during this trial reflected badly on Harry, and I think it is important to give this side of the case its proper weight before moving on to the more damaging material. The court heard allegations that a private investigator working on behalf of the Mail obtained the specific airline seat number of Chelsea Davy, Harry's former girlfriend, and discussed the possibility of placing someone in the seat directly beside her during an international flight. If that account is accurate, that represents genuinely disturbing conduct by any reasonable standard, and Harry's legal team argued forcefully that it came uncomfortably close to what most people would recognize as stalking behavior.
And today, when we found out the results, he was doing a speech at Chatham House and his voice was shaking, he was all alone, he was clearly broken by the whole thing. Yeah. His wife wasn't by his side.
The court also separately heard direct testimony from Elton John and his husband David Furnish, who said under oath that they genuinely believed their newborn son's private birth certificate and confidential medical records had been improperly and unlawfully accessed by someone at some point. There was also separate testimony specifically about how Harry first learned he had been named godfather to his former nanny's child, an appointment he argued could only have reached the public and reached him through an improper source of some kind, given that this particular piece of information was not publicly known or available at that specific time. These are, without question, serious allegations regardless of where any individual observer ultimately lands on the broader case and its outcome. and they genuinely deserve to be taken seriously on their own individual terms and their own merits, rather than simply being dismissed wholesale as part of an overall loss just because the larger case did not succeed.
Let me just guide you back across the pond to what is happening here, because it involves an old friend of yours and mine, Prince Harry, the rogue son, who is crash landing into the UK today. And there's this gigantic furore, as always, has erupted around the little entitled brat.
But here is the legal distinction that actually decided the entire outcome of this case, and I think it is genuinely the single most important thing to understand about why a case involving these kinds of serious allegations still collapsed so completely. Alleging a privacy violation, however serious and however genuinely felt, is simply not the same thing as proving one under the specific legal standard that actually applies in a civil case of this kind. Because this was a civil case, the standard was not beyond reasonable doubt. It was the balance of probabilities, meaning simply what was more likely than not. Even applying that comparatively lower legal bar throughout the trial, the judge repeatedly and consistently looked for specific, concrete evidence demonstrating that any given particular piece of information could genuinely only have come from unlawful means, rather than from any of the numerous ordinary channels through which royal information typically circulates. Again and again, the court heard alternative explanations from male witnesses, and in a significant number of instances, the judge found those alternative explanations more persuasive than the allegations. Many of the individual claims involved in this case dated back 20 or even 30 years at this point, meaning they relied heavily and often almost entirely on inference and reasonable assumption rather than on any direct documentary evidence that could be independently examined and verified. The ruling itself was explicit and unambiguous on this specific point. Inference alone, however serious and however genuinely felt the underlying concern behind it might be, is generally not legally sufficient on its own to decide a civil case of this scale and this consequence.
I would make is on hypocrisy that Harry has made a fortune, gazillions of pounds, trashing his family and revealing the most extraordinarily intimate secrets.
Invading everyone else's privacy.
So this is the great royal privacy invader trying to put up this fake sword of the Shining Knight, taking on the journalist for doing exactly what he does.
Now, let's get into the reactions to this verdict, because Piers Morgan and Tom Bower did not hold back at all once the ruling landed, and their comments genuinely generated their own separate wave of coverage that continued for days afterward. Morgan opened his show almost immediately after the ruling was announced and did not soften a single word of what he said. "A good day for them," he said, calling it a good day for journalism, a great day for press freedom, and a very bad day for what he described, in his exact words, as ginger whining, treacherous little weasels. Those were not paraphrased. That is what he said, live, on camera. Bower's assessment was considerably more measured in tone, but arguably even sharper in its underlying substance and implication. The judge has been remarkably brave, because to punch Harry on the nose so violently, and although he hasn't called him a liar, implies that he didn't believe a word of his evidence. Morgan went considerably further, drawing directly on his own personal history with this family that stretches back decades. He said Princess Diana used to call him regularly during his time as a newspaper editor, that their conversations were recorded with her full and explicit knowledge at every stage, and that she was sent a full copy of anything before it was published, which she would then return to him with her own personal amendments and corrections. His central argument throughout was that the idea every single royal story ever published over the decades came exclusively from phone hacking or other unlawful methods simply does not match how he personally believes many journalist-royal relationships have actually functioned in practice over the years. That information also comes from conversations, trusted contacts, and people who simply choose to speak voluntarily. The same panel discussion also revisited Harry's ongoing and long-running dispute over state-funded security in the UK, which continues to generate its own separate coverage entirely apart from this specific verdict. Morgan and commentator Kinsey Schofield argued that requesting that level of protection for private visits risks making them look more like official royal engagements in all but name. Family lawyer Paula Rowe pushed back directly and firmly against that specific framing during the discussion, pointing out clearly that Prince Andrew received publicly funded security protection for years under circumstances that were genuinely very different from Harry's own situation. a comparison which some observers see as evidence of an inconsistent standard being applied unevenly across different members of the family, while others disagree entirely and see the two situations as simply not comparable. When Tom Bower was directly asked during that same panel discussion for his own honest opinion about the future of Harry and Meghan's marriage specifically, his answer turned out to be considerably more cynical and considerably more pointed than most of the surrounding commentary on that particular subject tends to be. He said plainly that he believes the marriage will continue going forward, but specifically for reasons of practical necessity rather than genuine ongoing love between the two of them. In his own stated assessment, the two of them now depend on each other more than at any previous point, precisely because their various business ventures have significantly underperformed relative to early expectations, leaving them, in his considered view, increasingly reliant on protecting a shared public image together rather than continuing to genuinely and independently choose each other for their own sake. Harry was far from the only claimant involved in this case, and I think the other individual names attached to this litigation deserve real and specific attention rather than simply being treated as a footnote to Harry's own much larger story. Elton John, Elizabeth Hurley, Sadie Frost, David Furnish, former MP Simon Hughes, and Baroness Doreen Lawrence were all involved, and reports suggest some genuinely believed the case had strong prospects before the judgment landed. Simon Hughes, the former MP, publicly described the outcome as very disappointing in his own statement afterward. And Tom Bower, despite years of consistent and often harsh public criticism of Harry specifically, said the person he personally felt the most genuine sympathy for out of every single claimant was Baroness Doreen Lawrence, whose son Stephen Lawrence was murdered in a racially motivated attack decades earlier, a case that became one of the most significant in modern British legal history. Bower specifically noted the complexity of her position. A woman suing a newspaper that had, for years, campaigned to help bring her son's killers to justice. Some commentators have specifically pointed out, in the aftermath of the ruling, that Harry has the financial resources and the established public profile to absorb a defeat of this particular scale in a way that not every individual claimant attached to this same case genuinely can, given their very different personal and financial circumstances. Paul Dacre, the Mail's editor-in-chief and a longtime, frequently named target of Harry's own public criticism across multiple interviews and his memoir, responded to the verdict with the kind of characteristic bluntness that has defined his entire career in British newspapers. He criticized Harry's memoir directly, arguing it exposed private family matters while Harry simultaneously complained about his own privacy being violated. "There isn't a laundry in the cosmos big enough to wash all the dirty linen Harry has aired about his own family," Dacre said, adding that Harry's privacy arguments take not just the biscuit, but the whole tin. He went even further than that, claiming publicly that Diana herself had, during some of the most difficult and painful years of her own life, personally read and genuinely trusted the Mail as a publication. A claim that supporters of the newspaper's overall defense argued makes the broader case that this specific paper operated unlawfully against the family for decades considerably harder to accept at face value, given that relationship. There is also a detail about the run-up to this trial that I think matters considerably more than it might initially appear to on the surface. Reports indicate that before the case even formally began, Harry's own legal team quietly explored the genuine possibility of a financial settlement around the Christmas period, well over half a year before the eventual judgment was actually handed down. According to those same reports, the Mail specifically declined that settlement opportunity and chose instead to defend the case fully in open court, a decision that, once the verdict came in overwhelmingly in their favor, a great many commentators pointed to afterward as reflecting genuine institutional confidence in their legal position, alongside a real willingness to have all of the underlying evidence tested publicly and rigorously, despite the genuinely enormous financial cost that decision ultimately carried for both sides involved. And the actual cost involved genuinely was enormous, on a scale that most people following the case struggled to fully grasp until the specific figures started circulating. Under the loser pays principle that applies broadly in this kind of civil litigation in the UK, the unsuccessful party in a case can be legally required to contribute meaningfully to the winning side's own legal costs on top of covering their own. Before the trial had even properly begun, the court was told that combined legal costs across both sides could realistically approach £40 million in total. By the time the full proceedings had actually concluded, after 11 weeks and 45 separate court days, some reported estimates put that combined figure considerably closer to £50 million altogether. Insurance arrangements of some kind may cover part of that overall figure, and further separate insurance policies may cover additional amounts on top of that, but depending entirely on the final cost order issued by the court and the specific policy terms and conditions involved in each individual arrangement, there could still be a genuinely substantial financial balance left outstanding once everything is finally settled. A further formal hearing is scheduled for the end of July specifically to determine exactly how those substantial costs ultimately get allocated between the various parties involved in this litigation. All of this landed cumulatively during what a great many commentators have separately and independently described as one of the single most difficult stretches of Harry's entire public life since he formally stepped back from royal duties several years ago. Reports indicate that Buckingham Palace had initially offered him accommodation during this specific UK visit, an offer that was later formally withdrawn after a decision on accepting it was reportedly not made within the required timeframe. Meghan and the children remained in the United States throughout the entire duration of this visit, adding yet another layer to an already difficult and heavily scrutinized week. And entirely separately, running in parallel to the court case itself, there were reports circulating that the Invictus Games Foundation, the cause most closely and personally tied to his public identity above nearly everything else he has been involved with, was facing its own significant financial pressures and genuine fundraising difficulties heading into the coming games. To a great many observers watching all of this unfold in real time, across multiple simultaneous news cycles, it genuinely looked like another opportunity for reconnection with the palace had quietly slipped away yet again, while his family stayed an entire ocean apart from him throughout. Right at the exact moment, a £50 million legal defeat became the week's single dominant headline across every major outlet. The legal costs themselves are still not fully and finally determined at this point, pending that further hearing scheduled for the end of July. The other individual claimants involved in this case are still processing, in their own ways, what this verdict actually means for their own personal positions and their own respective next steps going forward. And the broader question of how all of this ultimately affects Harry's public standing over the coming months remains, genuinely and honestly, still an open one that nobody can answer with confidence right now. What do you think? Does the Charlotte Griffiths message contradiction genuinely change how you personally read everything else Harry testified to under oath throughout this entire 11-week trial? Or was this outcome always realistically going to come down to the applicable legal standard itself, regardless of any single specific piece of evidence like the Facebook messages? Drop your take in the comments, subscribe if you haven't already, and I will see you in the next one.